debt disputes are difficult enough within one legal system. But when a dispute spans two or more jurisdictions, such as when a Vietnamese company owes money to a foreign creditor, or when the deal is structured across borders, complexity multiplies fast. Different laws, different procedures, different languages, and different enforcement realities can slow recovery and drain leverage. In this video, we explain how to navigate cross-jurisdictional debt disputes involving Vietnam, and how to structure a strategy that actually converts a foreign result into local recovery. Cross-jurisdictional disputes commonly appear in four scenarios. 1. A Vietnamese buyer defaults on payments to a foreign supplier. 2. A joint venture or shareholder dispute where one party is offshore. 3. An international arbitration award that must be enforced against assets in Vietnam. 4. Assets, bank accounts, or decision-makers spread across multiple countries. In each case, the legal problem is not only who is right, but also where can you enforce, and how fast can you reach assets. Core challenges: why foreign wins don't automatically collect in Vietnam. There are four major hurdles in multi-jurisdiction disputes. First, legal definitions and procedures differ. What is easy to prove abroad may require different evidence presentation in Vietnam. Second, language and documentation requirements can create friction. Third, and most important, foreign judgments and foreign arbitral awards are not automatically enforceable in Vietnam. In most cases, you must go through a Vietnamese court procedure for recognition and enforcement before local enforcement measures can be pursued. Fourth, cross-time zone coordination delays decisions and slows document handover, when speed is often the difference between recovery and a disappearing debtor. It is critical to separate two categories. Foreign arbitral awards. Vietnam is a party to the 1958 New York Convention, and recognition and enforcement follow Vietnamese court procedure aligned with convention standards and local rules. Foreign court judgments. Recognition typically depends on an applicable treaty or, in some cases, the principle of reciprocity under Vietnamese law. This is why winning abroad is only half the work. The other half is choosing the right route into Vietnam, based on what you won and where the assets are. The contract dispute clause often determines everything. If the clause is clear, Vietnamese courts, international arbitration, or a specific foreign court, your options are more predictable. If it is ambiguous or missing, you risk jurisdiction fights, parallel proceedings, or costly delays. The key decision is not comfort, it is enforceability. If the debtor's assets are mainly in Vietnam, selecting a forum that is enforceable in Vietnam is often more important than selecting a familiar overseas court. To enforce a foreign court judgment or a foreign arbitral award in Vietnam, you generally apply to the competent Vietnamese court for recognition and enforcement. The process typically requires a court-ready dossier, Vietnamese translations, and, depending on the document, legalization or other formalities. The court will also consider whether grounds exist to refuse recognition, including procedural fairness issues and whether recognition would conflict with Vietnam's basic legal principles. Timing varies. Some cases move smoothly, while others take several months or longer depending on documents, service, objections, and complexity. Cross-border disputes often fail due to coordination, not law. Foreign counsel may win on the merits, but documentation arrives late, translations are inconsistent, or local procedure is not planned early. That is why Vietnam side coordination matters. A unified strategy should control timeline, evidence packaging, and filing sequence, so you don't win a decision abroad while losing the enforcement window in Vietnam. A foreign contractor obtained a favorable outcome abroad against a Vietnamese counterparty, but payment did not follow. The creditor's real objective was enforcement against assets in Vietnam. After preparing the recognition dossier, translations, and procedural filings in Vietnam, the foreign result was recognized. The creditor then pursued available enforcement steps through the competent authorities and recovered a substantial portion of the amount over time. Details adjusted for confidentiality. The lesson is simple: cross-border disputes are won when you plan enforcement early, not when the debtor is already out of reach. Here are 4 practical rules. 1. Plan enforcement from day 1, before you file abroad. 2. Engage Vietnamese counsel early, especially if assets are in Vietnam. 3. Build your evidence and claim narrative so it can be transported into Vietnamese procedure cleanly. 4. If assets are only in Vietnam, consider enforceability over familiarity when choosing the dispute forum. Cross-jurisdictional disputes are not won through legal theory. They are won through strategy, coordination, and local execution. If your company is handling a cross-border debt dispute involving a Vietnamese party, contact LTS LAW. We work with international legal teams to turn foreign outcomes into Vietnam enforcement, and unresolved invoices into real recovery. Visit lts.com.vn for a cross-border debt consultation. Because borders should not protect bad debtors.